case number
Tell me.
254-3247, Daniel Arevalo. This is a case of an ounce of prevention, hopefully is better than a pound of cure. I got on the case.
Did you catch that? A Whizzinator, yes, that's literally a fake device to cheat a drug test. And now, this case just went from bad to felony level messy.
After he'd already appeared in court and got his bond conditions, he has random urinalysis. He travels a lot. September, 7 days, 18 days in October, 21 days in November, what I would propose.
What does he do for work?
Construction, and would you like for him to?
Sure.
Come on up.
So this is what we normally do when they get called upon. They have to go to a Quest Diagnostics, wherever they are. Quest is all over the country, and they need a test at a Quest because it's a reputable lab.
I mean, we're talking Montana and Wyoming at times. What I was going to suggest is, could he call pretrial on Monday and give them his schedule and take a portable breath device?
I'm okay with that. Sure.
Okay.
Yes.
That way.
Notice how Judge Fleischer is carefully balancing work travel with strict alcohol testing. This is a common challenge in bond cases. Courts want to allow defendants to keep working, but still maintain accountability. What do you think? Should judges be this flexible with travel or keep restrictions tighter?
I'm happy to do it. Yep.
And it's a DWI, so we're making sure he doesn't.
Done.
Okay.
Sounds good with me.
I'll let with pretrial know.
Yeah.
So portable, no more random choice, correct?
Correct. Waive the fee. Are you ready?
Yes.
It's 254-3247. Okay, good luck.
Thank you, Your Honor.
All right, guys.
Like I
Take care.
say, ounce of prevention.
Mr. Sims. Come on.
Judge, I have Kelly Savage, who I got appointed to today. The state has confirmed that there is a new address for the complainant, and so we have an amended MOAB for you,
Okay.
just for your signature, Judge. And we're gonna get her to sign it as well. You want her to come up, Judge?
No,
Okay.
no, you're
Just have her
good.
sign it.
Yeah.
Okay. Thank you, Judge.
Of course. Thanks, Mr. Sims. Runty,
Judge, how are you?
did everything work out with the case from last week?
He's here because we have a motion to amend bond conditions, and then I guess he needs to sign the.
I waived the signature.
Oh, I didn't know that.
Yeah, I told them I waived it so that he wouldn't have to come down here.
Well, we're here.
Okay, just whatever you need, God.
Mind signing the motion since we are. I worked hard on getting that together.
Come on, man.
So I just need to have him wait for pretrial, and then he can go over the 49. Thank you, Judge. Appreciate
Absolutely,
it.
for sure. All right, hi, counsel, coming up. LaKayla, I'll hit you up next.
I'm here for Eric Ramirez.
Okay,
I'm approaching on his bond condition.
who's your client?
Eric Ramirez.
Oh, that's the client for Eric Ramirez. I thought you meant you were appearing for an Eric. Okay, tell me,
So I'm approaching on his bond conditions.
did he just get out of jail?
He did not just get out of jail. However, he still does have the bond conditions that were set by the magistrate. He had his felony dismissed recently.
Okay, come up, Eric Ramirez. So it looks like he had a UUMV that was dismissed last week, and then in October, we have the terroristic threat here. What happened in the terroristic threat, Morgan, please?
So in the terroristic threat, the complainant and the defendant are in a dating relationship. The complainant told the officers that her and the defendant had gotten into an argument, and the defendant stated.
And there it is, the gavel drops. The judge has officially lost patience. When you keep breaking court orders, mercy runs out fast.
Second.
Oh.
Okay.
The defendant stated, "I'm going to kill you." He then told her, "I'm going to have someone kill you." And the complainant stated she believes the defendant's threats were credible. And I believe the bond conditions was just no contact. There was a moat put in place, and then no drugs or alcohol, because there were allegations of alcohol use in the offense report.
What would you like, counsel?
Yeah, so I would just ask the court to revisit the no alcohol condition.
In the sworn PC statement, there's no allegation of alcohol use. There is a statement in the OR, but there's no sworn statement for the court to make the finding that alcohol was a factor.
I mean, I can still, even if it's not in there, I can still add as a condition of bond that I don't want him drinking. How old are you, sir? Okay. Tell me about the allegation. Normally, when I have a case like this where there's a threat, where there's an assault, where there's something of this nature, and there's either an alcohol, drug, anything like this, I usually do it as a condition that they can't. So, Morgan, tell me about, is there something with regards to alcohol?
It was just when the officers arrived and they were speaking to the defendant, they believed that he was intoxicated. I think they noted in the offense report there was a strong odor of alcohol coming from his person. And I think that's the only allegation of alcohol in this case.
Okay, that's why I did it, because when they get there, they allegedly either see him in some kind of state. And what I want to do is I do it as an effort to prevent any future thing from happening. Do you understand? Dude, if you're sick, we're going to have you go. Are you feeling under the weather? Get out. Like, come on, go.
That's a brutal call out. The judge isn't sugarcoating anything here. He's practically holding up a mirror to this defendant's reality.
Okay, I'm not prepared.
Whoa. Threats like, I'm going to kill you immediately raise the stakes here. Even if alcohol wasn't directly tied to the charges, Judge Fleer isn't taking chances. That's why bond conditions often go beyond the exact allegations. They're designed to prevent future risks. Do you agree with the judge's cautious approach here?
Perhaps later on, if he's behaving well, we can reapproach. But at this time, I'm not ready yet. It's only been, 60 days, give or take? So, okay. Come back if he's behaved well, then I'll take it off a little bit later. All right? Yes, sir. Please.
New events on Mr. Oriana Carranza.
Okay.
There was a hold on INS Olden, November 11th. He was sent directly to immigration. The court date that was given was November 18.
Okay, Tony, he did get sent to immigration?
Yeah, he got to immigration.
And now he's back.
Now he's back because they lifted the hold and put another hold on December 27th. They transferred him here.
Right.
Which is kind of unusual. Usually they keep him until they work.
No, it's.
I know it varies. I understand. But so November 11th.
This is an important turn. Instead of just punishment, the judge is pivoting toward rehabilitation, trying to find the why behind the behavior.
There was a place of hold. He had a court date on November 18th. He was in immigration. They brought him back here. They put another hold on December 27th. So during the time period that we're talking about, when he missed his court date, he was in immigration.
So what do you want?
Just give him a lower bond. Just I did my work.
I understand. If you want it, I will. But if he posts that.
Then take him back. Maybe. Unless I
I want
look
to
at the
take care of the
case.
case first, because if they take him, I'm going to end up issuing a warrant.
I said, that's why I want $100 bond, to show that I don't think he's going to make $100. But it's
Morgan.
from 2,500.
We'll just defer to the court on
Yeah,
this
all
matter.
right. I'll set it at $100, Tony, but remember, at $100, is that what you want? But remember, if he makes that bond and they send an immigration, that's going to tack on another 3 months.
That's why I didn't argue on the other case, because you can't make it even if you put $1,
Got it.
unless
Okay.
I contribute to it.
Judge, in regard to the signature for the.
Thank you.
After driving while intoxicated, second offense, you are facing up to a year.
Notice how the family keeps pleading for leniency while the court focuses on accountability. Tough love in real time, folks.
You're in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 30 days in jail with credit for the 12 days that you've done. It looks like the state is moving to reduce it to a deduction.
This is a huge moment. Judge Fleer is spelling out crystal clear. A third DWI won't just be a slap on the wrist. It's a felony with years in prison. Imagine standing in court knowing your next mistake could mean 10 years behind bars. Would that warning be enough to scare you
Bond revoked, and that's a big deal. It means no more freedom until the court sees progress. Actions finally caught up with him.
straight?
Mr. Medrano, what you need to understand, 1 and 1 make 2. 2 and 1 make 3. So the next time you pick a DWI, it will be a third, and you will be looking at a felony charge. A minimum of 2 years in prison, a maximum of 10 years in prison. Do you understand? If I were you, I wouldn't get in the car even if you'd had a sip of alcohol because you were taking a humongous risk. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record and you can never take it off. Do you understand?
Yes.
Is this what you want to do?
Yes.
How do you plead to the offense of driving while intoxicated, guilty or not guilty? I will find you guilty. I'm going to suspend your ability to drive for 1 year. Do not drive until you get a license. Good luck, sir. You can waive the fee and then the surcharge, which is $6,000.